Good evening to one and all present here. I, Apurva Pathak, student of Rani Durgavati Vishwavidyalaya, welcome you all in the webinar on Irretrievable Breakdown of Marriage, Evolution in Divorce Law, organized by Team LicitElite. Team LicitElite focuses on providing assistance to law students in self-grooming while acquiring better knowledge by generating an exclusive learning platform through activities like law classes, blog writing, mood preposition drafting competition, etc. It also aims to connect with legal experts to design better learning opportunities. It provides lecture series of subjects accessible for free at its YouTube channel. Further on request, it also provides notes in the form of PowerPoint presentation as well as documents and PDF. LicitElite provides one-on-one digital coaching to students through video conferencing on request of the student. Goal of the organization is the ultimate welfare of the student as they are the hope for tomorrow. And LicitElite invests in future and assists you in practicing your foremost expertise. There are 3 marital remedies available to parties. That is, restitution of conjugal rights, judicial separation, and divorce. But Indian Judiciary is demanding irretrievable breakdown of marriage as a special ground for divorce. Because sometime while granting decree of divorce, the court faces some difficulties due to some technical loopholes in the other theories of divorce. So to discuss and analyze the value aspect of the theories of irretrievable breakdown of marriage and to throw light on the report of Law Commission of India and Supreme Court observation on the topic, we have with us Dr. Ashu Dhiman. Ma'am is an assistant professor at Central for Legal Studies, Geet Ratna International Business School. Her qualification include BA LLB Honors, LLM, PhD NET, and JR. Her specialization is in business law and family law. Ma'am has been into research and teaching for more than a decade. Ma'am has several research papers published in international and national journals and has appeared as resource person in webinar and presented in various national and international seminars and conferences. She has given interviews and guided enormous law students all over India. Ma'am, I would like to request you to take the session forward and enlighten us with all your words.
Thank you, my dear Purva. Thank you for the introduction. And good evening, all of you. I think I am audible. So, today I am going to talk about a very thorny question, that is divorce. But before going through what divorce is, first of all, we need to know the basis, the actual thing upon which the theory of divorce has been opined. I would like to talk about two important things. First one is wedlock and then deadlock. We will talk about the time when a wedlock becomes a deadlock and how society has responded to it and how judiciary has responded to it, how legislature has responded to it, how the Law Commission of India has responded to it. So, first of all, the very basis, what I'm going to talk about is wedlock, that means marriage. As we all know, marriage is the very foundation of family, the fundamental foundation of society, that is family, and marriage is actually related to it. So, the important question is, what is the concept of marriage? Because to understand what is the concept of divorce, what is the concept of irretrievable breakdown of marriage, we need to understand what is the concept of marriage. If we talk about time immemorial, when we came to know from back then, we came to know that marriage is actually a sacrament. If we talk about Hindu law, marriage actually is a sacrament. So I can see some comments here that voice is breaking. I hope right now it's going good. I'm trying. Hello. I think there is problem with voice, but I would like to resolve it first. Okay. So I hope now I am audible. So I would like to tell you that marriage has always been a sacrament. Hindu marriage has always been a sacrament. Sacrament, what do we understand by it? That it has its religious values, it's related to dharma, it is related to religion. Time says that it is an indissoluble union. It is an indissoluble tie. It shows that marriage actually is a romantic concept if we talk about history. It is a euphoric concept where it is called an indissoluble tie which cannot be broken. But seeing the time, with the passing of the time, with the changing in the society, we have noticed that this concept of indissoluble union of marriage has been changing. Right. So the thing I want to talk about is the concept of marriage, which is changing by time, and the evolution of marriage and evolution of divorce. Now, if we say that marriage is an indissoluble union, then what about that particular thing when we say that the basic purpose of marriage is actually procreation? If somebody is not able to procreate, because obviously we know that the human race should be perpetuated on planet if you procreate. This is the truth. This is the fundamental. This is the basis of marriage. That is why people marry. But what if somebody is not able to procreate? Here comes the frustration theory of divorce. Because the marriage gets frustrated because the very basis of marriage has been retired. Now, heading towards the fault theory, the fault thing of it, I would say that after going through the frustration theory, when it applies when that a person is not able to procreate, then secondly, there comes the fault thing. That yes, we say that marriage is a sacrament, right? We say that marriage is a sacrament, but some here, when the basic purpose of marriage frustrates, then obviously it is called that the basic purpose of the marriage has been frustrated, so it can be dissolved. So it is no more an indissoluble union. Let us go through the PowerPoint presentation. Secondly, I was talking about the theory that is fault ground theory. There are many other grounds which are provided under Hindu Marriage Act. You can see here that first of all, if we talk about marriage, that it is an eternal and indissoluble sacrament under Hindu law. It is often said that marriages are made in heaven and solemnized on earth. As I have discussed earlier, that it is a very, very romantic and euphoric concept. Now, it has been observed that marriage has been the highest dharma. It has been said that we attain moksha after getting married, because obviously after getting married, a human procreates, reproduces children, and there is a production of son who ultimately take us towards moksha after doing pindadan, if we talk about Hinduism. So Manu has declared that let mutual fidelity continue till death. This, in brief, may be understood to be the highest dharma of husband and wife. According to Pasthamba, marriage was meant for good deeds and for attainment of moksha. When it was observed in the Cat Munich versus Basant Kumar in 1901 that under Hindu law, marriage was a sacrament. As I have discussed earlier, that it is a union which is indissoluble. And it is the union of flesh with flesh, bone with bone, to be continued even in the next time. वो कहते हैं ना 7 जन्म का रिश्ता है, तो वो 7 जन्म का रिश्ता जो है वो डेडलॉक कैसे बन जाता है? Now, there was a declaration made by Manu. It has been considered to be an unjust declaration by many. So, Manu had made the declaration that wife cannot be released by husband, neither by sale nor by desertion. But he might have another ideology regarding this, but people have considered that the declaration made by Manu was actually an unjust one. Because the declaration made by Manu was applied to women and not men. Therefore, there was an element of inherent justice on the wife of Hindu law. Now, this was the reason. There was there was many other things. I cannot say that it is the only thing, but from this particular theory given by Manu, the things changed for women in the society. Because the Sati Pratha was there, the Parda Pratha was there, there were many other Prathaएं were there, जो women को degrade करती थी, जो injustice करती थी women. So to protect the women from the injustice and to save sacramental aspects of marriage, the Hindu Marriage Act 1955 was enacted. Even Deret said that divorce was introduced in Hindu law for the protection of helpless women when they were ill-treated. It was never Parliament's intention to give husbands matrimonial variety at their option so as they could retain a pleader. Now, what does the Hindu marriage law specify? Here, I just want to talk about 1955's Act, where the Hindu Marriage Act, which applies on Hindus, the Jains, Buddhists, and Sikhs. And under Section 13 of the Act, there are various fault grounds provided. As we all know that we have studied during our law LLB, that there are under 13 clause 1, there are many grounds provided. One of them is adultery, another is cruelty, desertion for a period of like 2 years continuously, and ceasing to be Hindu, like conversion, and then incurability of unsound mind. I haven't written more here. There are more others like vulnerable disease or the leprosy, etc. Or renunciation of the world. They are also provided under Section 13 clause 1 of the Act. Now, in addition to this, in 1976, the amendment of 1976 in Hindu law, there was an addition there that was Section 13B, which provides for divorce by mutual consent. I'm going to talk about divorce by mutual consent because I have always been asked by the students that, ma'am, what is the difference between mutual consent divorce and irretrievable breakdown of marriage? Both are same hai na? So why do we call it different? They are different. We will discuss about it. Now, as we are talking about current Hindu law, so I would like to tell you that there are some matrimonial remedies which are actually in all three, which that is restitution of conjugal right. That if a person is staying apart, has gone out of the company of the spouse, then the other spouse who has been affected by it may ask the court for restitution of conjugal right under Section 19 of Hindu Marriage Act 1955. The second remedy available is judicial separation under Section 10, which actually goes around the Section 13, the grounds provided, the fault ground provided in Section 13 plus 1. And then divorce is provided as a remedy that comes under Section 13 and Section 13B of Hindu Marriage Act. Even 1A, 13(1)A is also included. Now, let us talk about the theories of divorce. As talked earlier, divorce at will theory. Divorce at will theory actually is not available, it's not applicable under Hindu law. Divorce at will theory is somewhere Islamic concept because Hindu law doesn't recognize it. where a person can divorce his wife at his will. Whenever he wants, he can divorce his wife. Pronouncing talaq, not the triple talaq as of now. We cannot say this. And secondly, the frustration of marriage theory, as I have talked to you earlier, that when a person is not able to procreate, then it is clearly evident that the person, actually the basis of the marriage is procreation, and if a person is not able to procreate, and there are many other things, I'm just specifically talking about this because it actually frustrates the basic purpose of marriage. Thirdly, we are going to talk about guilt of fault theory. Now, this is the actually most recognized theory under Hindu law, because Section 13 clause 1 talks about guilt. Because as I have discussed earlier, that marriage is such a thing. The concept is changing. For me, when I was a youngster, or when I was about to marry, so the concept of marriage for me was that a person who is caring, who can be a friend of me, I should marry that person. But the ideology regarding marriage of my mother or my grandmother, great grandmother, must be way different from mine. Or if I talk about the male member of the society, definitely that must also be a different perspective. They might have thought that हमें अपनी फैमिली की केयर करने वाली लड़की चाहिए, पर्सन में उस समय पर ये भी सोचा जा सकता था कि हमें फैमिली की केयर करनी, जो बच्चों को पाले, घर देखे, किचन देखे. They might have thought this was the ideology, these were the things, but now it has always been changing. Even man is looking for a friend who can share things, who can share all the problems he's facing in the society, living in the society, or professionally he's facing something. So they think that now we need more of a friend than a wife, or a wife may think that we need more of a husband, more of a friend than a husband. But the things change. The concept, the ideology, as I have told you earlier, that ideology changes with the time, and it actually is changing. So I have already told you that the idea of marriage of my grandmother, my mother, mine, and maybe my daughter might have different, absolutely different. And secondly, if here I'm talking about the generations, if I talk about individual, maybe my idea of marriage, my concept of marriage may be different from yours. So the thing is, because the concept, the ideology related to marriage is different, so is the thing with divorce. Some may think divorce जो है उससे घर में बहुत ज्यादा प्रॉब्लम्स आती हैं, फैमिली बहुत ज्यादा सफर करती है. One need to sacrifice, one need to stay in the matrimonial relationship all the time. उनको sacrifice करना चाहिए, ठीक है ना. अगर कुछ प्रॉब्लम आ रही है तो ठीक है ना, we can ठीक है, मिलकर पैचअप कर लेते हैं, उसको सॉल्व कर लेते हैं, but we should not go for divorce. But some may think, why to live in this relationship जहां पर मुझे इतनी परेशानी हो रही है कि मैं नहीं रह पाऊंगा या नहीं रह पाऊंगी. तो दोनों ही आइडियोलॉजीज डिफरेंट हैं. तो रही बात फॉल्ट की, बिकॉज वी आर ह्यूमन, एंड एक्चुअली द थिंग इज, इफ आई हैव अ फ्रेंड, मेरा एक दोस्त है और मेरी उससे नहीं बनती है, so I'll say like, okay, I don't want to be in this friendship, and I don't want to be a part and parcel of this friendship, so let us move on. तुम अपने रास्ते में, अपने रास्ते. It is about the friendship, because ऐसा हम friendship में कर सकते हैं, but not in the case of marriage. But the thing is that yes, it hurts. It actually hurts. It violates Article 21 of the Constitution, where it provides right to life and personal liberty to the person, that we cannot be forced to live in a marriage if we don't want to. Right. So there comes a theory that is irritable breakdown theory. I'll come to that after this. So the guilt theory is something, because we being human want to change, want to see the other person according to us, and we keep on looking for faults, the guilts of the person. Right. So that is actually the basis of fault theory of divorce. After that, as I have talked earlier, that the concept has been changing. The concept of marriage has been changing. Now, what happens? Earlier, the marriages were arranged. Now, the marriages are actually on the will of the parties, like a love marriage, for example, that they voluntarily want to get married, are married and they, with their consent, the parents' consent or their own consent, they go and get married. Then गलती तो सभी से होती है, हमने अपनी मर्जी से शादी की बट हमसे गलती हुई, तो हमें ऐसा लगता है, me and my spouse think that we cannot live in this relationship. So here comes the entry of mutual consent theory, that they agree on this point. वो मानते हैं कि हम दोनों साथ में नहीं रह सकते, तो वो एक जॉइंट पिटीशन डालते हैं जहां पर वो बता सकते हैं कि दिस इज द रीजन दैट वी गेट, वहां पर उनको दे डोंट नीड टू शो एनी फॉल्ट एक्सेट्रा, बट दे मे गो एंड file a joint petition and get a decree of mutual consent. Now, next theory, which actually we are going to talk about, is irretrievable breakdown theory. We are here for that theory only, and Hindu law actually does not recognize this theory. Somewhere in Article 13, Clause 1A, introduction has been provided of this theory. Irretrievable breakdown theory means when marriage has completely broken down, the wedlock has become the deadlock. Jahan par two people do not want to live. Marriage is actually not a gold cage in which you can enter and lock yourself and throw the keys out. You can come out of the marriage if you feel that your relationship has ended. There is no point to live in this relationship. It has been ended. It is a dead marriage. Then you should have a right to come out of the marriage. This is what this theory says. Now, this concept was first introduced in New Zealand in Maserati versus Maserati 1921 New Zealand Law Report 1786. It was introduced in England in 1969. But in India, the debate is still continuing. And first, there is no doubt it is way older, but it was 71st report of Law Commission of India, which titled the Hindu Marriage Act, the Irretrievable Breakdown of Marriage as a ground of divorce. Now, talking about the 71st report, I hope you have all received the report. The Law Commission under chairmanship of Shri H.R. Khanna presented its report on April 7, 1978. After giving a brief introduction about the topic, the Law Commission has given the present law and current theories of divorce. They also dedicated a chapter on irretrievable breakdown theory, explaining everything related to irretrievable breakdown theory. They also provided in chapter 4 the merits and demerits of the theory and retention of other grounds. There is also a question that other grounds must be retained with the theory or not. With this irretrievable breakdown of marriage, if we separately make this a ground, then should other grounds be retained or should they be ended? And in the chapter 6, they are talking about requirement of living apart, that a couple wants. Actually, it has not been implicated so far, but the suggestions given by the Law Commission of India were like that there must be a requirement of living apart, that the couple must be, say we can give them a time कि अगर आप 5 साल तक साथ में नहीं रहे हैं, ना रहते हुए, separately रहते हुए, तो we can grant you a decree of divorce on the ground of irretrievable breakdown of marriage. They have also talked about the safeguards, because definitely they are going to be stress. There must be some hardships, either be financial hardships or there must be some problems to children of the marriage. So definitely not only the society but other people who are directly connected to that marriage suffer due to divorce. So Law Commission of India in its 71st report has said that the children out of the wedlock must not suffer when it breaks up. So they have talked about safeguards under chapter 7 of it. And lastly, they have recommended amendment in Hindu Marriage Act, talking about section 13. We already have section 13B already in the Hindu Marriage Act, and after they want section C, D, E to be included, where they can provide it as a separate ground of divorce. And there are many other things which talk about, like we cannot keep those particular other grounds, and we can keep. There are different debates on that topic as well. So let's come to the next point, the important point I was trying to discuss with you all, that mutual consent divorce and irritable breakdown of marriage. They are actually not same. First of all, I must tell you, when we talk about mutual consent divorce की बात हो रही है, तो मतलब कि दोनों पार्टी, दिस इज एक्चुअली कंसेंट थ्योरी, म्यूचुअल कंसेंट थ्योरी, जहां पर दोनों लोग, both the spouses want to go out of the marriage, and they agree on this point that yes, we cannot live together and we should be apart. But in case of irretrievable breakdown of marriage, let me refer to a judgment that is really recent one. It is Munish Kakkar versus Nidhi Kakkar, and it has been given under in 2019. So Supreme Court has resolved the dispute of matrimony and dissolved the marriage and given using the inherent powers under Article 142 of the Constitution. And here, what happened? I'll just give you the facts in a nutshell. There was a woman, there was actually the spouses who were married in 2000. In 2000, they get married, and after 2 months living with the husband, the wife goes to Canada. And she returns only after getting the permanent resident of Canada. Then she got the citizenship in 2002, actually. Even after coming back, there were continuous quarrels between the parties, going to the same. पंचायत इंटरवेन, पंचायत बीच में आती है और उनको कहती है कि ठीक है, अगर तुम्हारे बीच में लड़ाइयां होती रहती हैं तो यू जस्ट सेपरेट फ्रॉम द फैमिली से अलग जाकर रहिए और अपनी शादी को बचाइए. इवन देन उनके बीच में लड़ाइयां होती रही. एंड वाइफ अगेन वेंट टू कैनेडा. नाउ द husband himself filed a complaint, actually the petition of divorce under Section 13 Clause 1 of Hindu Marriage Act on the ground of cruelty before the lower court. The appellant contended that loneliness and lack of cohabitation had caused him extreme physical and mental torture. Despite his reluctance to go to Canada, he also signed the documents to go to Canada, but he never went. But he wanted to save his marriage, so he also took this step as well. But he couldn't reach Canada, as I have told you earlier, and the respondent, the wife, has in her arguments have blamed him so much that he has aborted, he has forced to abort her, and he has inflicted cruelty, so and so and so. So after hearing, actually, she didn't want to get divorced. Husband said that I want divorce under Section 13 Clause 1, that is cruelty, and wife objected it, and wife said I don't want to get divorced. So after hearing the arguments from both the sides, the additional district judge granted a decree of divorce, against which the appeal was filed before the High Court of Punjab. And interestingly, the High Court set aside the decree of divorce, attributing various allegations exchanged between the parties to wear and tear of marriage and inflamed passions. The High Court judge had opined that these were not adequate to knock down the bills of marriage. But when it was appealed to Supreme Court, the Supreme Court observed, I am going to read that observation of Supreme Court for you, that the relationship appears to have deteriorated to such an extent that both parties see little good in each other, though the respondent insists that she wants to stay with the appellant. This is the thing I want to tell you by talking about mutual consent, divorce, and irretrievable breakdown of marriage theory, because here students are always confused that both are actually the same. In fact, the Law Commission of India in its 217th report has started the interaction with this particular thing. I would read this for you because this is really necessary to know that whenever the question of inclusion of irretrievable breakdown of marriage as a ground of divorce is mooted, the opponents argue that divorce by mutual consent introduced in the Hindu Marriage Act in 1976 more than covers the situation. People think so, that this is the reason the students think so. But this is actually not the thing. It is important to note that mutual consent requires the consent of both the parties, and as I have discussed earlier. And if one or other does not cooperate, the said ground is not available. And they are saying that irretrievable breakdown of marriage, on the other hand, is a ground which the court can examine. And if the court, on the facts of the case, comes to the conclusion that the marriage cannot be repaired or saved, divorce can be granted. Now, here you can see that Law Commission itself has said that there is a difference between the two theories. वहां पर दोनों कंसेंट दे रहे हैं, लेकिन यहाँ पर ऐसा हो सकता है, जैसा कि मैंने आपको मुनीश कक्कर वर्सेस निधि कक्कर के केस में मैंने आपको बताया कि वाइफ जो थी खुद तो शी वाज लिविंग इन कनाडा, वो वापस नहीं आ रही थी, जब भी आ रही थी शी वाज फाइटिंग, बट शी वाजंट रेडी टू गिव डिवोर्स. शी न्यू दैट मैरिज हैज बीन इरिटेबली ब्रोकन डाउन. कुछ भी नहीं है, इतने साल हो गए, 2000 से लेकर 2019 में दे गेट डिवोर्स, वो भी सुप्रीम कोर्ट तक जाने की बात. सो दिस इज द थिंग कि see, the Law Commission has to say that the human life is of short span. So one has a right to live it with personal liberty. So if somebody, like in this case, 2019 में जाकर उनका डिवोर्स हो रहा है, पहले उन्हें लोअर कोर्ट डिवोर्स ग्रांट कर रही है, लेकिन उसके बाद अपील जाती है हाई कोर्ट के अंदर, और हाई कोर्ट कह देती है कि वो तो नॉर्मल वेयर एंड टेयर ऑफ फैमिली है, थोड़ी बहुत झगड़े हस्बैंड वाइफ पे चलते रहते हैं, दैट इज नॉट अ प्रॉब्लम, इस ग्राउंड पे हम उसको डिवोर्स नहीं देते, हम इस डिवोर्स की डिग्री को खारिज करते हैं. They dismiss it, and after that he has to file an appeal in Supreme Court to get his marriage dissolved, because he was actually because denying the divorce, denying the granting of degree of divorce amounts to cruelty itself. The women or any person, I'm not talking about women or men, I'm talking about an individual, I'm talking about a spouse, if he or she denies, because he or she can see, because he want to put that person in mental agony कि इसे परेशान करना है, मुझे तो पता है मैं खुश नहीं हूँ और इसे भी खुश नहीं रहने देना है, तो what she will do or he will do, that person will definitely deny to divorce. And this is the difference. There comes the difference. अगर बात इतनी ही होती कि दोनों ही समझते हैं कि डिवोर्स हो जाना चाहिए हम दोनों के बीच में, तो उतना आगे बढ़ने की जरूरत नहीं है, इस थ्योरी को लाने की जरूरत ही नहीं. लेकिन जब सिचुएशन इस तरह की हो गई है कि जहां पर फॉल्ट थ्योरी से जाकर जो थ्योरी है वो शिफ्ट हो रही है इरिट्रेबल ब्रेकडाउन ऑफ मैरिज थ्योरी में, कि जहां पर उधर से भी ब्लेम आ रहा है, इधर से भी ब्लेम आ रहा है, they are blaming each other. There is a blame game, that's all, nothing else. No feeling of emotion, love has been left in the marriage. So this is irretrievable breakdown of marriage. Now, as I have talked earlier, I have already discussed the idea behind the report, that the 71st report of Law Commission of India also opined that human life has a short span and situation causing misery cannot be allowed to continue indefinitely. So the question that was raised by 71st Law Commission report was that whether irretrievable breakdown of marriage can be made a ground for divorce under the Act, and if so, किस हद तक, up to what extent, and there must be some conditions actually, there must be some safeguards, as I have told you earlier that it has dedicated a full-fledged chapter on it, because the report is of 44 pages and it has given a chapter on safeguards as well. Whoever is going to suffer from this kind of dissolution of marriage, that person must be safeguarded first before passing the decree of divorce. Now the questions, the situations described by the Law Commission 71st report, that if there is an agreement of separation between the married couple, that there must be a separation. They have talked about it, that it is up to the legislature that they can give sufficient time to a particular time of separation to the parties. They have just put it as an example that separation for more than 5 years should be sufficient proof, and no non-cohabiting shall be considered as a sufficient fact to prove irretrievable breakdown of marriage. Now, non-cohabiting itself is proving that there is nothing left in the marriage. When the couple is living separate during young age and do not want to reconcile, this situation shall be considered as sufficient proof. as I have discussed earlier, that the ideology behind this insertion of this particular ground was that human life is really a short span, and we must, fulfill all the things, all the responsibilities, and we must not be tied up in that particular marriage, which is actually not fruitful. So next thing was that no petition for restitution of conjugal rights has been filed from either side. दोनों अलग रह रहे हैं, and both actually this thing will be the conclusive proof here that nobody has filed a restitution of conjugal rights petition for a continuous period during the period of 1 year arising out of rift shall be a conducive ground of irretrievable breakdown of marriage. Next thing, it has said that continuous separation for the period of 1 year, along with the suspicion of misconduct, mental or physical cruelty from either party, discovering adultery. Yeah, you can say here there is actually inclusion of fault grounds here when we are talking that there is a continuous separation of 1 year, and the parties can say that the other person, the spouse of other side has physical cruelty or like adultery or illicit relationship, whatever. So that definitely it has made another person, the other spouse, to live separately, or living together is not impossible. So if no attempt to settle the dispute relating to which the case is pending for judicial separation or restitution of conjugal rights or divorce for 3 years or more has been made by either party. Now in some cases where submission of either party that he or she cannot live together is enough to consider the case of marriage being irretrievably broken. Now, as talked about it earlier, that somehow Section 13, Clause 1, which was inserted in 1976, it introduces the concept actually. Either party to the marriage was also given a right to apply for dissolution of marriage by decree of divorce. Like where there has been no restitution of funds, there are two situations actually which are provided here. कि अगर restitution of conjugal rights की degree आपको मिल गई है, लेकिन उसके बाद भी restitution नहीं होता है एक specified period तक, तो the other party, either of the party may go to the court and file a petition for divorce. And secondly, if another thing was or where there has been no restitution of conjugal rights for the period specified therein after passing the decree of restitution of conjugal rights, and non-cohabitation. And non-cohabitation has been made. So these two things are there that अगर आपके restitution of conjugal rights की degree pass कर दी गई है, लेकिन still non-cohabitation है, so it frustrates. It actually becomes the time when irritable breakdown of marriage continues. But here, if we say, going to the back slide, if we say that it actually purely the basis of this particular section is irritable breakdown of marriage, that is not true, because the decree for restitution of conjugal rights has been attained on the fault grounds of divorce. Actually, it is not directly taking us to the irritable breakdown theory, but that will be the situation when actually it will happen. Now, fault and no fault theory is discussed. So, should the Supreme Court grant divorce solely on the basis of fault of the party, or should it look for irretrievable breakdown of marriage be cause for divorce? Now, the question here is that these two theories are entirely different, but somewhere irretrievable breakdown marriage or the no fault theory contains fault in itself, because when we talk that one party comes to the court and says my husband or my wife has committed adultery or has inflicted cruelty upon me, has done this and that, etc., etc. So there is someone, one party has coming to us at the court. So that is actually the fault ground divorce or fault ground theory. And if we talk about no fault theory, now here actually it is somewhere interconnected with the fault theory, where if we talk about the case of 2019, Manish Kakkar versus Nidhi Kakkar, there in that case, it also happened that actually the husband started the motion, the petition on the basis of fault ground, that was section 13 clause 1, that is cruelty. So he has started it from there, and after that, the blame game started between husband and wife. He is saying this and she is saying that. They are just blaming each other, and both come to the theory that actually everything has been broken down. The marriage is actually not fruitful at all. So what they have decided that it is actually a irretrievable breakdown of marriage. The marriage has been broken down. So the question in front of Law Commission of India was that should there be actually some fault grounds to rest in the act, or they must be removed, and there must be only incorporation of irretrievable breakdown of marriage ground and mutual consent. So they are of the opinion that they have asked through a questionnaire that what exactly should be done in this case. So there must be many opinions about it. Some said that no, divorce, the fault theory must be there, and we can incorporate in addition to it. But some judges and some advocates were of the view that no, actually there is a need of mutual consent theory, because the concept of marriage has been changed, the society has been changed, and society is actually accepting it as a ground for divorce. So they wanted mutual consent theory and irretrievable breakdown theory of divorce. But still the debate is continuing. There is no ground, there is no basis, nothing substance has been done so far about it. So as I have discussed earlier, while giving the example of 2019 judgment, the recent judgment of Manish Kakkar versus Nidhi Kakkar, there is a shift to no fault theory actually. When Manish files a petition under Section 13, Clause 1 of cruelty, and then it shifts to irritable breakdown theory, while starting from lower court to higher court and then to Supreme Court, it has shifted and it has become the irritable breakdown theory. But actually, the ground is actually not available, and the court has actually said that we are invoking our powers under Article 142 of Constitution of India, because there must be complete justice to the parties. So here are two cases where a petition for judicial separation was dismissed, and secondly, there was actually a husband who has obtained a degree of judicial separation, but he wasn't allowing, after the end of that particular time period, he wasn't allowing the wife to recommence cohabitation. So the divorce petition cannot be filed by husband, because we have talked under Article 13 Clause 1A that either of the party may file. अगर तब भी रिजम्पशन नहीं होता है, कोहैबिटेशन रिज्यूम नहीं होता है, तो कोई भी पार्टी जो है जाकर कोर्ट में डिवोर्स के लिए फाइल कर सकती है. बट अगर ऐसा हुआ, यहाँ पर ऐसा नहीं होता है. हस्बैंड क्या करता है, हस्बैंड अलाउ ही नहीं कर रहा है वाइफ को वापस आने के लिए. So this is the case here. Then it shifts to no fault theory actually कि और husband खुद जो है वो divorce file नहीं कर सकता है यहाँ पे, because he is actually, wife wants to come and he doesn't want her to come. So यहाँ पर इस चीज को वो invoke कर रहा है. Now the important thing here, the second report which comes in 2009, that is the 217th report of Law Commission of India. The Law Commission of India said that immediate action is recommended to introduce an amendment in Hindu Marriage Act 1955 to include irretrievable breakdown of marriage as a separate ground of divorce. They also suggested that court should examine whether adequate financial arrangements have been made for the parties and the children. Now the thing is, the Law Commission of India in its 217th report has actually referred to 71st report of it, and it has said that in that particular report, it has already been provided with all the things we actually want the legislature to look upon. Now, as we talked earlier, actually, because we have talked earlier that there is nothing such law related to irretrievable breakdown of marriage. So Supreme Court is having, only the Supreme Court is having such powers under Article 142, which makes it unique, because the basic purpose of that article is to provide complete justice to the parties involved. So where law or statute may not provide any remedy, the court has power to settle a dispute in a manner that would befit the facts of the case. It is with the objective that the court finds it appropriate to grant divorce in case of irretrievable breakdown of marriage. There is thus recognition of futility of completely failed marriage being continued only on paper. Now, heading towards the Supreme Court judgments, I have already discussed many, but there are many important judgments which are left. The judiciary in India, the time to time, started raising the demand of including such a special ground for divorce under the present law because it was facing problems while deciding such cases. Because सुप्रीम कोर्ट के सामने जब केस आता है वो इस तरह से आता है कि बहुत सारी चीजें जो है वो पहले हो चुकी होती हैं और ब्लेम गेम ही चल रहा होता है हस्बैंड और वाइफ. Now, there was a case of Saroj Rani versus Sudarshan Kumar Chadda. Here, the Supreme Court has first laid down in upholding a decree of divorce following a consent decree of restitution of conjugal right that it is evident that for whatever be the reason, this marriage has broken down and the parties can no longer live together as husband and wife. If such is the situation, it is better to close the chapter. Talking about MS Jordan Digan versus SS Chopra, the Supreme Court has made a recommendation for a complete reform of law of marriage by introducing irretrievable breakdown of marriage. You may see that in every case, the Supreme Court is actually talking about incorporation of irretrievable breakdown of marriage as a separate ground for divorce in the Act. In Amarendra and Chatterjee, although I want to tell you that there are cases like Savitri Pandey where Supreme Court has actually denied granting decree of divorce on a ground of irretrievable breakdown of marriage. Now heading towards Amarendra and Chatterjee versus Srimati Kalpana Chatterjee. Here the court held that Hindu Marriage Act does not contain any provision for dissolution of marriage by decree on the ground of irretrievable breakdown of marriage, and as such the court cannot grant a decree on the ground alone. So this was also happened in this case, and I have already referred a case of Savitri Pandey. And there are many other cases like Apurva Mohan Ghosh, V. Bhagat versus V. Bhagat. There are many other cases where court has suggested the legislature to include that particular ground as a separate ground of divorce under the Act. Now, talking about the very important judgment that is Neelu Kohli versus Naveen Kohli, that you must be referring it in while talking about the mental quality. It has provided us the definition of mental quality actually. So, in this case, the marriage has ceased to exist in substance, and in reality, there is no reason for denying divorce. And then the parties alone can decide whether their mutual relationship provides the fulfillment which they seek once the parties have separated and the separation has continued for a sufficient length of time, and one of them has presented a petition of divorce, it can well be presumed that marriage has been broken down. Marriage in such cases becomes a legal fiction supported by a legal tie. Refusing to sever the tie in law does not serve the sanctity of marriage, but only shows scant regard to the feeling of emotions of the parties. Even one case is left, Samar Ghosh versus Jaya Ghosh, 2007. In this case also, the Supreme Court has said there were also two parties who were actually married, and they were having a girl child as well, and they have got divorced after 22 years of their marriage. And the case was absolutely the same, that actually it was the marriage which was irretrievably broken down. कि दोनों तरफ से blames आ रहे हैं that husband has committed adultery, wife has done this, wife is filing FIRs against husband, although both are well placed, both were judges, and there were many other things happened in this case, and ultimately the Supreme Court decided that their marriage has already been broken down irretrievably. And last but not the least is Munish Kakkar versus Nidhi Kakkar. You all know the facts of the case and the judgment of the Supreme Court. Now, what are the reasons actually? क्यों नहीं बन पा रहा है ये separate ground of divorce under the Indian society? There are many problems related to this. First of all, I'm not talking about irretrievable breakdown itself, but I'm talking about the divorce itself. That whenever a person gets divorced, family breaks, there comes a social stigma. Actually, social taboo we call it, and it also when it is related to divorce only. Whenever either it be on fault ground, mutual consent divorce, or any other divorce, there is a taboo with you that you are a divorcee. And even the children from that marriage suffer. I'm not saying that in every marriage which has been broken, the children exist, but wherever exist, they actually suffer the broken marriage of their parents. They're the most innocent sufferer of the broken marriage of their parents. Secondly, if we talk about irretrievable breakdown of marriage, making it a separate ground of divorce under Hindu law, it will definitely attract the theory of divorce at will. Because it will be easier for people to get divorced. वो क्या करेंगे कि पेटिशन डालेंगे कि ठीक है इरेट्रेबल ब्रोकन डाउन हो गया, इतने साल से हम अलग रह रहे हैं, अभी छोड़ दो, खत्म कर दो इसको, तो उनकी मर्जी से होना शुरू हो जाएगा और डिवोर्स केसेस जो है वो बढ़ जाएंगे. इट कैन बी मिसयूज्ड बाय हस्बैंड, अ वाइफ, or anyone. The subject elements exist in the understanding of irretrievability and breakdown. The sacramental nature of relationship. Actually, if we say that we are changing with time, the society is changing with the time, but still somewhere we actually protect our culture, we actually respect our culture, and we definitely believe in the institution of marriage, and we definitely believe that it is a sacramental nature of relationship, and it will definitely be treated with liberty if this ground of divorce is available. So freely. Now, I would like to give some suggestions, though I have not worked much on it, but what I have thought that there must be setting up of family courts in the district, because this is actually the truth that whenever somebody comes to the court for divorce, the question in front of the court is that actually they think that there must be a settlement thing in this particular marriage कि किसी भी तरह से इनका settlement करें और ये शादी ना टूटे. Then rural women जो है, secondly जो whatever the suggestion I have provided, the second suggestion is laws to safeguard the rural women. Rural women are actually not aware of their rights, although it has been said that women empowerment जो है वो सबसे बड़ा reason है इंडिया में divorce का. तो कहीं ना कहीं हाँ सही है ये बात, बिकॉज हम लोगों ने उस समय पर ये गौर नहीं किया कि जो वुमेन है वो एक्चुअली सबसे पिछड़ी हुई है और उसको आगे लाया जाना चाहिए. और अभी जब वो उसे एम्पावरमेंट हो रहा है, उसे एनलाइटनमेंट हो रहा है, तो definitely आई एम नॉट सेइंग, आई एम नॉट अ फेमिनिस्ट, आई एम नॉट सपोर्टिंग एनी पर्टिकुलर जेंडर, बट आई एम सेइंग दैट अभी this is also true that women is the one who is actually misusing the law. If we talk about section 498A, they are misusing it. There are many women, but there are many other women. If we talk in the context of rural women, they actually do not know what is 498A. Actually, something is going like that with them in their houses, but they do not know. So the laws must be made to safeguard those particular women who live in rural areas. Then thirdly, law must be in line with contemporary practices, as I have discussed earlier, that social change, the society changes, and the law has to change. This is my point here. So there must be, as I have talked earlier while talking about laws to safeguard rural women, I have talked about section 498A, and I'm talking in this context actually that to safeguard some provisions related to marriage. Some provisions are like that which are actually women friendly. The provision must be human friendly and not particular gender friendly. The legislature needs to take it into consideration कि कहाँ पर किसी एक पर्टिकुलर सेक्स को हम अपग्रेड नहीं करें या डिग्रेड नहीं करें, कहाँ पर जरूरत है जस्टिस होना हो, जहाँ पर वहां पर ही उन लॉज को अप्लाई किया जाए. Then a speedy justice must be a priority of law, as I have discussed earlier कि 20-20 साल लग जाते हैं. एक मैं irretrievable breakdown की बात ना ही करूं अभी इस कंटेक्स्ट में, तो मैं ये कहना चाहूंगी कि अगर हम एक नॉर्मल ग्राउंड, एक नॉर्मल जो है हमारा फॉल्ट ग्राउंड है, उस पर अगर हम बात करते हैं तो वहां पर भी डिवोर्स लेने में हमें बहुत समय लग जाता है. इवन मतलब मिनिमम यू कैन से 5 years आर मिनिमम, 5 to 7 एंड मोर. बहुत आगे भी जा सकता है जब irretrievable तक पहुंचता है. Then I would like to suggest that irritable breakdown of marriage must be a separate ground for divorce and judicial separation, as well as I have mentioned in my next point, second last year. So I would like to say that it must be incorporated, because the thing is, I do not agree with that point that which was actually debated over when it was taken to 2000. In 2010, there was an amendment bill. तो उस अमेंडमेंट बिल में वहां पर कुछ पॉइंट्स उठाए गए थे कि सेक्शन 13C बना दिया जाना चाहिए, या सेक्शन 13D बना दिया जाना चाहिए, ई बना दिया जाना चाहिए, जहां पर 13C के अंदर ये प्रोवाइडेड है कि जो पार्टीज टू मैरिज हैं, जो डिवोर्स लेना चाहती हैं, वो इस ग्राउंड पर कि मैरिज हैज बीन इरिट्रेबली ब्रोकन डाउन, इस ग्राउंड पर वो आकर डिवोर्स ले सकते हैं. They have to prove something like they are living separately from 5 years, 10 years, or whatever. And then there was another point. In 13T, it was there, and it was said that it must be checked upon that there is not any such kind of hardship to the men. And if like women has a right to oppose it, if she is a respondent and husband is an appellant, she has right to oppose the divorce. अगर वो irritable breakdown पर divorce मिल रहा है उसे, तो she has right. So there must be certain safeguards. There must be certain other things to be inserted जहाँ पर दोनों ही sexes को, दोनों ही persons को safeguarded फील हो, जहाँ पर दोनों को ये ना लगे कि हाँ दिस लॉ इज एक्चुअली वुमेन फ्रेंडली, दिस लॉ इज एक्चुअली मेन फ्रेंडली. सो इस तरह के कुछ सॉल्यूशंस जो हैं लेजिस्लेचर को लेकर आने चाहिए मेरे हिसाब से. And next is basic instruction regarding sex and importance of family to be imparted to the youth in school. This is actually very important, and I can see in my son's school it is actually being done. They are providing the basic knowledge, the good touch, the bad touch. They are actually providing, and that is really good. It must be provided. The other ground I have already discussed, the other suggestion I have already discussed while I was discussing it to be made a separate ground for divorce, and it must be for judicial separation as well. So the very important thing I have already said that marriage law needs to be gender neutral, and this is actually need of heart because अभी ऐसा नहीं कर सकते हैं कि हम सिर्फ women को, because if you are saying that women has been empowered, I'm not going against some particular gender, but I am just saying this is the logical thinker, this is the logic that if you are saying that women has been empowered, women का empowerment हो गया है, women is working and I'm working, so how can I claim everything like if I'm saying that I need maintenance but I'm earning, but why do I need maintenance from my husband? So the laws must be gender neutral. There must be financial hardships to men as well. So these things must be taken into consideration while implementing such law. And I would say that although we have discussed that Law Commission of India in 71st report has said that they are confused about this, that retain karna hai ki nahi karna hai fault grounds ko. So I would suggest that they must be merged together, because basically the thing is the thing which is happening is that actually the irretrievable breakdown जो है वो आता कहाँ से है, basis क्या है, वो actually fault grounds से आता है, जहाँ पर एक spouse को ऐसा लगता है कि the husband or the wife has committed adultery or cruelty, etc., etc. I'm not talking about the frustration of marriage theory, because if somebody is unable to procreate or impotent, that is a different matter. We cannot say that, because it totally frustrates the purpose of marriage. So I'm not taking those things into it. I'm talking basically about those 5 important things जहाँ पर adultery, cruelty, etc. आता है, तो वहां पर इन सबको मर्ज कर दिया जाना चाहिए, because they are actually related to each other. Then as I have discussed earlier, that Supreme Court has got the power under Article 142 of Constitution of India to like this kind of because they cannot they can do complete justice, so for providing irretrievable breakdown of marriage grounds divorce. Then the power to grant divorce on the basis of irretrievable breakdown must be given to the lower court actually. Need for setting up of a uniform civil code, and this is actually important because there are many religions in our country, and definitely we respect them all, but there must be actually a uniform civil code so that equality can be done. Next point is homosexuality must be made a ground of divorce. Actually, I have inserted, you must be surprised that I have inserted it, but the thing is, when somebody, for example, A marries to B, and A being a wife comes to know that actually B is a homosexual, then it actually attracts the divorce provision. So I'm not saying that they are not human beings, but these things must not be hidden actually. If it happens, then it must be made a ground for divorce. And definitely HIV test before marriage must be made compulsory. So here I end the discussion, but I know I know that I have taken so much of time, and it's around 1 hour, so I'm open to questions.
Thank you, ma'am, for enlightening us with your wisdom of words of wisdom. We hope that all the participants have gained some knowledge about the topic. So here are some of the questions I would like to put forth. So there is this question. He's asking that how can we, under which article one can file divorce petition on the district court on the ground of irretrievable breakdown of marriage?
Well, I'm sorry, you cannot use any article for that matter. And actually, this was actually the whole lecture about that we do not have any such law actually. So, my dear, whoever you are, you must be aware that this is actually not a law, and any article actually is not providing it. It is Hindu Marriage Act which is actually providing it, and I'm talking about Supreme Court's power to invoke Article 142 to do complete justice.
So one person is asking that the parties, the wife and husband, been living separately for 2 years. They are not applying for divorce, but the wife wanted a divorce. So how can they like apply and get the divorce? Like the husband is not willing.
If the husband is not willing, so you need to go for fault grounds only.
Okay. So similar question was there that if one party does not put forth that they wanted to divorce and that do not agree with the other party to file divorce, but the other party is feeling a lot of pain being in that marriage. So how can they get divorce?
I'll give you the same answer, because there definitely be a fault in the other person if you are thinking that you cannot live in that marriage. So you must go for that particular ground, and obviously you can file a petition.
So there are some most of the time some people like tend to have issues, and they like false allegation, they apply false allegation on the other party. So how can we like remove this loophole and get a better understanding that this case is not
Yeah, that is true. That is true about related. This is actually the worst reality of divorce law right now, that I have talked earlier, that most of the women take the benefit of Section 498A of the Indian Penal Code, and definitely there must be some provisions made to safeguard the interests of men in this case.
There's this boy, he was asking that could you please again like simply explain the irretrievable breakdown like in a word or two, and give a simple example. He was not able to understand the whole theory, it seems.
Okay. I would like to tell you that the irretrievable breakdown of marriage is a situation when a husband and a wife being into marriage are not actually living together. For example, one of them has filed a petition for divorce already on the fault ground, and the second person is not ready and willing to get divorce, or don't want to go for mutual consent divorce. तो यहाँ पर बात शुरू हुई फॉल्ट थ्योरी से, लेकिन सामने वाला, जैसा कि मैंने आपको बताया कि जो कनाडा जाने वाली विमेन का केस है, वो खुद तो कनाडा चली जाती हैं, वो वापस आती तब है जब उनको पीआर मिल जाता है 2002 में। उसके बाद आने के बाद भी लड़ाइयां होती हैं, और उसके बाद वो फिर से कनाडा चली जाती है, सेपरेट हो जाती है। तो वहां पर हस्बैंड जो क्या करता है, वो एक पिटीशन फाइल करता है डिवोर्स के लिए, द फॉल्ट ग्राउंड, क्वालिटी के ग्राउंड पर। मैं एक बिल्कुल हिंदी में बिल्कुल उसमें बताना चाह रही हूँ आपको, बिल्कुल इनफॉर्मल लैंग्वेज, इनफॉर्मल तरीके से, कि वहां पर वो कनाडा चली जाती है और वो दोनों के बीच में कुछ भी नहीं है, और हस्बैंड जो है क्वालिटी के लिए डिवोर्स केस फाइल कर देता है। तो वहां से वापस आने पर वो कहती है कि मुझे डिवोर्स लेना ही नहीं है। तो यहाँ पर क्या है, जब जो हस्बैंड ने ब्लेम लगाए हैं, वो काउंटर ब्लेम कर रही है वहां पर, तो कोर्ट जो है वो इस बात से सेटिस्फाई हो गई कि एक्चुअली इन दोनों के बीच में कुछ टाई, कुछ बॉन्डिंग है ही, क्योंकि क्योंकि देखिए मैरिज का जो रिलेशनशिप है इट इज एक्चुअली based on love, marriage, affection, respect, tolerance towards it. तो यदि ऐसा है ही नहीं, तो definitely it is the case of irretrievable breakdown of marriage.
One student wants to know that what's the difference between judicial separation and divorce, and then you have already explained the irretrievable breakdown, so they want to know the difference between them.
Yeah, I have told you earlier that there is a difference that when it is a time when a court, you may go to the court and ask for judicial separation and not divorce. Okay, this is actually interim part, जो बीच का पार्ट है जहाँ पर अल्टीमेटली आपकी मैरिज जो है वो डिसॉल्व नहीं होगी, पर आपको कुछ समय के लिए अलग रहने के लिए कह दिया जाएगा. अगर आपको उस टाइम पीरियड के दौरान लगता है कि हम अलग नहीं रह सकते हैं तो वी कैन रिकंसाइल. बट इन केस ऑफ डिवोर्स क्या होता है कि डिवोर्स के केस में यह है कि आपका शादी जो है वो खत्म हो चुकी है, पूरी तरह से खत्म हो चुकी है, बीच का कोई भी रास्ता नहीं बचा है. So this is the basic difference between the two.
And there was this question that a party was there, and the lady was 16-year-old when she got married to the man, and now she is like wanting to get her dowry money back and get a divorce. Now, not that time she was not knowing what's happening, and her parents gave lot of dowry to the man, and they got married, and now she wanted to get a divorce and get all the money back.
But the question arises that how can she get married at the age of 16, first of all, and secondly, what are actually the grounds she wants the divorce on? That it is the only ground that she got married in the age of 16. So this condition is not actually clear. So I must like to say that the other questions can be sent through mail to this particular organization so that I can answer them, because I think we have faculty of time. It's above 7, so 6, sorry.
Thank you, ma'am, for such a vibrant session. I would like to thank you all the participants for joining us together and knowing more about this topic. And you all can visit the YouTube channel of LicitElite and get the recording of this webinar and more knowledge about the other sessions regarding law. Thank you all for joining in. Thank you, ma'am.
Thank you so much.